Good morning, everyone. My name is Scott Connolly, and I want to welcome you to our presentation this morning on 2021 developments in Massachusetts employment law. I'm a partner in Verril's Boston office, and with me this morning is my partner, Tani Alvarez, who's sitting in Portland. This morning, we're going to cover a number of new cases in Massachusetts, which you may not have heard much about because all of us were dealing with COVID-related issues for much of 2021. But there have been some interesting developments in terms of case law in Massachusetts in employment issues. We're going to be discussing a retaliation claim under the Massachusetts Domestic Violence and Abuse Leave Act, a federal appeals court dismissal of a wage act claim because of a union collective bargaining agreement, and also a new type of claim that's been developed under case law by the Supreme Judicial Court that provides a cause of relief that didn't exist before for employees asserting rights under the Personnel Records Act. We'll also be discussing a state appeals court case that dealt with issues relating to overtime misclassification and also attorney general enforcement actions in 2021. Tani, do you want to discuss briefly what you'll be covering?
Yeah, following Scott's update on the things that are happening at a state level within the Commonwealth, we'll then jump into a federal update and we'll talk about, unsurprisingly, COVID a little bit, give you an update there on best practices. We're going to talk about employee mobility and things that you should keep at top of mind as we have a larger percentage of individuals who are either working from home and transitioning between careers with the Great Recession. And then if we have time at the end, we'll talk a little bit about updates occurring with the National Labor Relations Board and what we foresee happening in 2022. So thank you for joining us, and I'll turn it back over to Scott.
The first court case that we'll be discussing deals with retaliation claims under the Massachusetts Domestic Violence and Abuse Leave Act. Next slide. The case is Osborne Trestle versus the Children's Hospital Corporation, and it was a case by the highest court, issued by the highest court in Massachusetts, the Supreme Judicial Court, in August of 2021. And in Trestle, the court ruled that on the elements of a retaliation claim under the Domestic Violence and Abuse Leave Act, that an employer could be liable where it took away or rescinded a conditional offer of employment after the job applicant disclosed that she was a victim of domestic violence and that her abuser had violated a protective order that she was seeking to enforce. Slide. Next. The Domestic Violence and Abuse Leave Act is General Laws, Chapter 149, Section 52E, which is relatively new as it was enacted in 2014. And it requires Massachusetts employers of 50 or more employees to permit an employee to take up to 15 days of job protected leave in any 12-month period when the employee or a family member of the employee is the victim of abusive behavior. And obviously the purpose of the Leave Act is to obtain, for an employee to obtain medical, legal, or counseling services, to obtain a protective order from a court, or to meet with a law enforcement official. An employer can't do certain things. An employer is prohibited from interfering with an employee's attempts to exercise the right to take leave and from taking adverse action or otherwise discriminating against an employee for invoking those rights. And the employee must provide appropriate advance notice of the need for a leave. Next slide. So in this court case that went to the SJC Trestle, the plaintiff was a registered nurse. She pursued claims for violations of the retaliation and interference provisions of the Domestic Violence Leave Act against the hospital. She alleged that she was the victim of repeated stalking, threats, harassment, abuse, and overt threats, and had obtained a harassment protective order that barred the abuser from contacting the plaintiff making social media posts about her, and going to her home or workplace. 3 months after the protective order issued, Trestle applied to the hospital for employment. She claimed the hospital aggressively recruited her, invited her to several interviews, contacted her references, and ordered a background check, and ultimately offered her a staff nurse position. The hospital sent a letter to the plaintiff listing her start date and noting that employment was conditioned upon completion of reference, background, and licensure checks, a fitness for duty assessment, and passing a new hire clinical orientation test. Next slide. So she was issued a photo ID, an employee ID number, and training schedule, and everything looked like she was about to start employment. But in the weeks leading up to her start date at the hospital, the plaintiff's abuser violated the protective order by posting threats and false statements about the plaintiff on social media. The abuser tagged the hospital on these disparaging and threatening social media posts, and the plaintiff reported the abuser's violation to the police and contacted the hospital's HR department. She disclosed the abuse of the protective order, gave the hospital a copy of the order, and indicated that she was cooperating with law enforcement to enforce it. The hospital asked for information about the abuser, and an HR representative told the plaintiff that he planned to speak with the abuser to hear the other side of the story. Less than 2 weeks later, the hospital rescinded or took away her job offer. Next slide. The trial or lower court dismissed the plaintiff's retaliation and interference claims, and then the plaintiff appealed to the appeals court. And then the Supreme Judicial Court in Massachusetts transferred the case for decision and reversed the trial court's order dismissing the claims. In the court case, the hospital argued that the act should be limited to current employees who are performing services for the employer, not applicants who were about to start, and that dismissal was correct because the complaint did not allege that the plaintiff notified the hospital that she required leave or that she requested time off for any specific date. The highest court in Massachusetts found that the plaintiff's allegations suggested that she actually was in an employment relationship with the hospital, although she had not yet started orientation. The court also found that the limitation sought by the hospital would impede the broad remedial purpose of the act to protect employees who were experiencing the effects of domestic violence from adverse consequences at work. The court reasoned that if the act applied to current employees only, an individual would have no recourse when perhaps on the verge of achieving a measure of financial security, he or she was stripped of it by an employer who determined it would be inconvenient to accommodate the individual's protective leave rights. Next slide. The SJC also rejected the hospital's argument that the plaintiff needed to have requested a specific leave date, finding that the plaintiff had notified the hospital of the conditions that could have required leave, the existence of the protective order, the social media posting, and her enforcement efforts. Next slide. The takeaways from this case: an employee need not explicitly ask for leave to have protection from retaliation and interference under the Act. An employee need not know specific dates for which leave may be needed. The retaliation and interference provisions of the Act may extend beyond current employees to job applicants or successful candidates, though the limiting principle on this is clear, whether someone would fall into that sort of anticipatory employment status that the SJC recognized. Finally, if investigating, tread carefully in light of safety concerns. The plaintiff alleged that the HR representative said he intended to contact the abuser. One of the dissenting judges voiced concerns about making direct contact with the subject of a protective order and whether doing so is necessary or appropriate. Next slide. The next case we're going to discuss is a federal appeals court case that deals with the Massachusetts Wage Act in the context of a union environment where there's a collective bargaining agreement in place. The case is Rose versus RTN Federal Credit Union, and it was a case by the First Circuit Court of Appeals in June 2021. In the case, the First Circuit approved the dismissal of the plaintiff's state law claims under the Massachusetts Wage Act for failure to pay wages and overtime because she was a member of a union and RTN had an existing collective bargaining agreement, or CBA, with the union. Because the CBA governed her wages and overtime pay, her Wage Act claims were preempted by federal labor law. Next slide. The facts of this case are that the plaintiff Rose was employed by RTN as a member services representative, a non-exempt position. Her position was covered under the collective bargaining agreement between RTN and the Office of Professional Employees International Union, AFL-CIO Local 6. Rose typically worked at RTN's Hudson branch in Massachusetts, but periodically was assigned to the Dedham location. She claimed that going to Dedham increased her commute by 1 hour each way, and that RTN's failure to pay her for extra time violated the Massachusetts Wage Act. Rose also claimed that RTN violated a state regulation that provides that an employee who regularly works at a fixed location must be paid for the extra time and expense caused by traveling to a different work site. Rose's lawsuit against RTN sought unpaid wages and expenses plus overtime for work weeks that exceeded 40 hours because of the additional commuting time. Next slide. First to note are the dangers under the Massachusetts Wage Act, which provides for automatic treble damages. In other words, if some liability is established, that amount is automatically multiplied by 3 or triple damages, which makes any violation potentially very expensive. The Act also provides for the recovery of attorney's fees and costs and individual liability for the president or treasurer or any officer having management of the corporation, and a 3-year look back for claims. Federal labor law, under federal labor law, the Labor Management Relations Act is a body of federal labor law that governs the interpretation of collective bargaining agreements between unions and employers. At issue for the First Circuit was the question of whether the Labor Management Relations Act preempted or superseded Rose's state law claims. If a plaintiff's state law employment claims require interpretation of one or more provisions of a collective bargaining agreement, then the claims come under the Labor Management Relations Act, and therefore federal law takes precedence. Not all disputes are preempted. If state law establishes a right independent of the collective bargaining agreement, the Labor Management Relations Act doesn't apply, and the state law claim may move forward, such as, for example, discrimination claims. The First Circuit's decision. The First Circuit affirmed the district court's dismissal of Rose's Wage Act claim because adjudicating the claims would require the interpretation of a provision in the collective bargaining agreement between RTN and the union. The collective bargaining agreement contained a provision that governed temporary transfers of employees between branches. The court's reasoning was that lawsuits involving the analysis or calculation of what is owed to an employee will almost always rely on an interpretation of the collective bargaining agreement, and therefore will be preempted by the Labor Management Relations Act. Whether RTN lawfully compensated Rose for her travel time, overtime hours, or minimum wage would require an analysis of the collective bargaining agreement's provisions governing hours of work, premium time, overtime, and classification of wages. And so therefore Rose was bound to pursue her claims through the grievance and arbitration provision of the collective bargaining agreement. The takeaway is that when an employer with a union is presented with a member's employee's threatened Wage Act claim or lawsuit, which could cover things like wages, hours overtime, pay, benefits, or travel time, the employer should carefully examine the provisions of the collective bargaining agreement to ascertain whether such claims may be preempted by federal law, which is powerful because it removes the issue of Wage Act application to the claim and the potential for those difficult Wage Act provisions that provide for treble damages and attorney's fees. The next case we're going to discuss is, I think, the most interesting development in Massachusetts law in 2021. And it involves an employee who was fired after sending a performance improvement plan rebuttal. And the issue is whether that is protected from termination or discharge by public policy. The case is Terrence Meehan versus Medical Information Technology Incorporated. In January 2021, the Mass Appeals Court upheld the lower court's dismissal of Meehan's claim that he was wrongfully discharged in violation of public policy. But on December 17th, 2021, the Supreme Judicial Court reversed the appeals court and held that an employer cannot terminate an at-will employee simply for exercising the right to file a rebuttal to a performance improvement plan to be included in the employee's personnel file. The facts of the case were that Terrence Meehan had been an employee at will of Medical Information Technology. He filed a one-count complaint or asserted one claim in Norfolk Superior Court, asserting that he had been wrongfully terminated in violation of public policy. Meehan claimed he was discharged because he submitted a rebuttal utilizing the mechanism outlined in the personnel record statute to a performance improvement plan on which he had been placed. The personnel record statute states that an employer shall notify an employee within 10 days of the employer placing the employee's personnel record any information that negatively affects the employee's qualification for employment or the possibility that the employee will be subject to disciplinary action. If there's a disagreement with any information contained in a personnel record, removal or correction of such information may be mutually agreed upon by the employer and the employee. If an agreement is not reached, the employee may submit a written statement explaining the employee's position, which shall thereupon be contained therein in the personnel record and shall become part of the employee's personnel record. The issue in this case was whether an employee's rights under the personnel records law to rebut documents in a personnel file creates a public policy that is sufficiently well-defined and important such that the exercise of that right brings an employee within the public policy exception to the general rule that an at-will employee may be terminated without cause. The appeals court held that it was not and refused to expand the process under Section 52C into a public policy protection from discharge, but the SJC reversed and found that it was. The takeaway from this case is that employers should tread carefully in responding to an employee's exercise of rights under the personnel records law, including an employee's submission of a rebuttal to a performance criticism and or a request to inspect a copy a personnel file. Now, we've all had or experienced an employee requesting a copy of their personnel file or to inspect it or submitting a rebuttal to a performance review or a performance improvement plan. But until this case, if the employer didn't comply with that, there really wasn't much of a penalty under the personnel records law because the personnel records law hadn't ever had a right of action for the employee to take action against the employer for failing to comply with the personnel records law. And what happened in this case was that the employee sought to submit a rebuttal to a negative performance or performance improvement plan that was a negative assessment of his performance, and the employer just thereafter discharged the employee. Probably out of pique for the employee not, viewing with concern the issues that were raised in the performance improvement plan. Now, had that happened a year ago, the employee really wouldn't have a right to pursue a claim under the personnel records law. But this new case in Massachusetts protects an employee from discharge under the public policy wrongful termination exemption.
Scott, a question that I think that we're going to see a lot more of, and I'd love to get your thoughts on, is I think you and I and other members of the department often will see situations where we'll get a phone call because a PIP or another performance improvement document has been provided to the employee, and the employee's written rebuttal is disrespectful, it has vulgarities within it, and kind of they've just gone off the handle. If that were to happen, do you believe, based off of this case, that there's then limitations on the ability to fire an individual based off of kind of inappropriate responses to performance improvement dialogues?
I don't think so. I think the situation you described sort of contains independent grounds, maybe for employee discipline or termination. I think that the issue here that was, I think, concerning, it was the mere submission of a rebuttal that the employee had the right to do under the employee under the Personnel Records Act, that simply prompted the immediate termination by the employer. But I think in the scenario that you're describing, there may be independent violations of policy or insubordination, that may violate other aspects of the company's policies, and could be, independent grounds separate from simply, filing the act of filing a rebuttal to a performance review.
Perfect, thank you.
The last court case we're going to discuss is an appeals court, the Massachusetts Appeals Court, weighing in on overtime misclassification issues. And the case is TAM versus Federal Management Corporation, and it's a Massachusetts Appeals Court decision from January of 2021. And in the case, Mary Jane Raymond was employed by Federal Management Corporation as a property manager at one of its apartment buildings. She was paid a salary and was classified as exempt from the requirement to pay overtime. Raymond became disappointed with her salary and complained to Federal that she felt overworked and underpaid, without more specificity. Soon after, Federal terminated her employment. After her discharge, Raymond filed a lawsuit asserting claims against Federal for unpaid overtime under the Massachusetts Minimum Fair Wage Law, and for retaliation under the Massachusetts Wage Act, Chapter 149. The appeals court affirmed dismissal of Raymond's claims and rejected her retaliation claim. The court noted that although an employee need not expressly invoke her statutory rights for a retaliation claim to be present, abstract or non-specific grumblings about pay are not sufficient to trigger the Wage Act's anti-retaliation provisions. In addition, the court discussed overtime statute of limitations, and claims seeking unpaid overtime are subject to a 2-year statute of limitations, are not told for fraudulent concealment, where the employer told the employee she was not exempt and therefore not entitled to overtime. I thought it might be interesting for you to understand and hear about what the Attorney General Wage and Hour Division in Massachusetts has been focused on in terms of enforcement actions. And these are not court cases, but I managed to discover some through press releases and other announcements, some of the Attorney General's Wage and Hour Division's enforcement activities for 2021, which I think are interesting. The first was a recording studio that was cited for $400,000 for failing to pay interns and earn sick time violations, and the restitution was owed to more than 60 unpaid interns. And I think 20 years ago when I started practicing in Massachusetts, it was very common for for-profit businesses to have unpaid internships, and that's certainly now all changed, especially since about maybe 7 or 8 years ago. There was a group of lawsuits in New York against the publishing industries and fashion industries and independent entertainment industry involving unpaid interns. And in fact, there were several plaintiff law firms opened in New York with advertising that all they did was represent unpaid interns. And so it's been an interesting shift, and certainly the Attorney General is still interested in whether interns are properly paid or not.
I think it's interesting too, Scott. I mean, it's always really interesting industries. I mean, we're not talking here about pavers. We're talking about like those jobs that I feel like college kids really want. Like, I'll work for free at a recording studio, so that people are almost throwing themselves in advertising or in television or recording. And then we see a fine like this. And I think that goes to what you and I hear a lot, where someone will be like, no, they say they want to work for free, or no, they say, you know, that they want to be an independent contractor, without understanding that there are these administrative issues that go along with it.
I think that's exactly right. I think some of the cases that brought this issue to the forefront in New York involved, you know, young people who were going into entertainment companies who thought they were going to be, you know, doing exciting things. And they ended up, you know, as part of their task were to pick up dry cleaning for people and do menial chores. And then all it takes is one unpaid intern to have a problem with the type of work they're doing, and they can assert claims not just on their own behalf, but it can easily turn into a class type of claim where they're asserting claims on behalf of all the interns, and that's what happened here in this recording studio case, probably, where probably one intern complained to the AG's office, and the AG investigated. And you know, when the AG or the Department of Labor is looking, they're looking for, you know, any violation that would affect anyone. It's not just limited to the single intern who complained.
And Scott, if this hadn't gone to the Attorney General's office, but instead a plaintiff had found counsel, what if you were going to estimate what this would have cost the recording studio? What would you estimate this having cost them, even if they weren't like accepting? Because I think this is something you and I hear a lot from clients, is they go back to the Attorney General wage and hour enforcement documents, versus when we're litigating a case and they say, well, wait a second, it only cost this recording studio $400,000. Why are you telling me that it's going to cost me $3 million when aren't we the same?
Yeah, it's a fantastic question. I think it's hard to tell, you know, if you take this $400,000 as being just a single multiple of what the potential, the calculated damages were for the interns. It's hard to tell whether there were penalties on top of that or any sort of multiple damages. But if it were taken by a plaintiff's wage and hour lawyer in Massachusetts, and the amount that the studio had failed to pay was $400,000, you'd automatically multiply that by 3. And the interesting dynamic in those situations or cases is that the lawyer for the plaintiff or plaintiffs really they're not really motivated to settle in those cases. It's very different than a discrimination case where there's a lot more uncertainty about liability. In a wage case, it's really the calculation as to whether, you know, there's liability. And then if there's liability, you know, the attitude of a plaintiff's lawyer in that type of case is, well, I'm going to get, you know, 3 times the amount automatically, and I'm going to get attorney's fees. It's provided by the statute. So, you know, although, so when you try to say, well, you know, let's settle for 1.5 of the amount, you know, there's really not a lot of motivation to settle in those cases, which makes them hard to resolve. The next assessment that I found was against, I thought was interesting, a cannoli factory, Chelsea Cannoli Factory, was assessed $105,000 in restitution and penalties. And the case involved from January 2018 through December of 2020. The company failed to pay workers for all hours worked, failed to provide a notice of a compliant earned sick time policy, retaliated against workers who tried to exercise their rights by firing them, and failed to furnish true and accurate timekeeping and payroll records. I think this is interesting because when the Attorney General is auditing or investigating an employer in Massachusetts, you'll receive a sort of an opening letter that's very scary and threatens criminal liability, among other things. But often, the employer will be asked to see other policies, written policies. So the Attorney General usually investigates a matter when they receive a complaint from an individual employee. That's the most likely scenario that prompts an investigation. But then the AG will often expand the scope of the investigation to all employees and will want to review whether the employer has compliant required policies like an earned sick time policy. So I think it's a lesson from this case to learn that it's good to review an employer's policies and have compliant policies, because they may be scrutinized in an AG investigation. And also with the cannoli factory case, the last point about failing to furnish true and accurate timekeeping and payroll records, what you want to do immediately is take as much control over an AG's investigation as possible by, if you're doing it yourself, to get in direct communication with the investigator, be cooperative, and make really best efforts to provide the documentation that they're asking for as quickly as possible. But if you're as an attorney representing an employer, that's the first thing I do is to reach out to the investigator, to establish rapport, convey that the employer is going to cooperate in a very professional way. Not to give up or give in to the Attorney General, but it's important to establish, a good relationship from the beginning so that you can have good faith discussions later on about, the scope of the investigation or, the scope of any potential problems or liability.
Scott, another thing that, I think is interesting about the cannoli factory, this situation, and I love cannoli, so I think this is an amazing example. But then B, I would guess that these failure to pay workers for all hours worked, we're not talking about the email that was sent at 8 o'clock, but probably more likely the donning and duffing question about when you get to work and when you check in, and the importance of employers understanding that. But also when we look at that failed to pay workers for all hours worked, if you have that charge or if you have that situation, you automatically have a twofold violation in most situations, because then you're failing to furnish true and accurate timekeeping and payroll records, right? So if we have clients or employers within the state who have a claim here for failure to pay for hours worked, plaintiff's counsel and clearly here the Attorney General is automatically going to tack on this second violation. So, earlier Scott mentioned the treble damages. You're not just looking at treble damages under one statutory provision, but you're also going to be looking at the second charge or claim concerning failure to furnish true and accurate timekeeping and payroll records. And I think it's interesting that this went all the way through December 2020. So we had 9 months of COVID time kind of within here, which then adds to not just the donning and duffing question, but also if there's a symptom check in place, how they were paying workers for that time.
That's exactly right. The last AG case is home health agency assessed $85,000 for failing to pay workers overtime and travel time, where the employer was paying employees at a reduced hourly rate for overtime hours worked, and also not paying employees for travel time between job sites. We do see this from time to time, employers not paying 1.5 times the regular rate for overtime hours worked, more than 40 in a given work week. And so, sometimes employers have misconceptions about what's permissible, that they can provide comp time instead of overtime hours to non-exempt employees, or that they can, pay a different rate. And that's not usually the case. There are a few mechanisms you can try to employ under the Fair Labor Standards Act regulations, but generally this type of sort of discretionary behavior by employers can be a problem, can turn into an overtime problem, and travel time has been really an issue I've seen a lot more of in the past few years, with different types of industries and employees traveling during the workday. And there's, some complicated regulations in Massachusetts for paying travel time. But if an employer has employees traveling after or during the workday for the benefit of the employer, payment of travel time should be looked at, very carefully to make sure the employer's not subject to an AG investigation, which again is just often prompted by an employee who perceives an inequity or violation of the statute that they can Google, and when they Google, they find plaintiff side employment law, wage and hour law firms that have summaries of the travel time regulations, and that leads to a phone call, and before you know it, the employee has a wage and hour lawyer, and it's a requirement to file an administrative claim with the Attorney General's office. So that's going to be the first stop, anyways, in that type of a case.
Scott, if I just can't afford to pay that time for travel in between the different job sites, maybe because it's like in home health care, a reimbursable type work, can I just change them over to independent contractors? I feel like we get that question a lot. Well, if it's an independent contractor, then do I have to pay them for that travel time in between the locations?
Yeah, I would say that using independent, if a company or a business in Massachusetts is using independent contractors, they should really look closely at that arrangement. And it's almost impossible to engage an independent contractor in Massachusetts because of the change to the independent contractor law in 2004 that was targeted towards the construction industry, but had unintended effects across all other types of businesses and employers. But it's the second part of the test for independent contractor status changed so that the test, that part of the test is that to be an independent contractor, the service provider or individual has to be providing a service that's outside the usual course of the company's business. And it's almost impossible to meet that test where the individual is providing any type of service that falls within what the business does. I mean, there are ways to sort of telescope in and out to try to make it work, but a home healthcare aide providing services to a home healthcare business as a home healthcare aide, it's hard to make the argument that they're outside the usual course of the company's business. And that's, independent contractor misclassification claims are very common, and they come from several sources. Most commonly, they come from the individual who is misclassified, and most commonly it's after there's been a termination or disharmony in the relationship or a termination, and that individual goes and speaks to one of our adversaries and they recognize that they can bring claims under the Wage Act for any type of compensation or benefits that they would have been entitled to as an employee. So that makes it very dangerous and difficult.
I think, Scott, you make a ton of really great points, and specifically that usually that question about classification isn't the initial kind of issue or concern, that it ends up becoming secondary, but that secondary issue ends up taking over from a financial standpoint, because I've never talked to an organization that just has one improperly classified independent contractor. And I think this goes back to the same thing we talked about with the recording studio case, is that there's a lot of situations where someone's coming into the organization saying, no, I don't want to be an employee, I want to be an independent contractor. And it could be for a variety of reasons, whether they want to make their own hours, they're trying to stay away from the IRS for one reason or another, child support, like whatever the reasons are, but understanding that simply accepting that they want to be an independent contractor is not the standard. And I think you did a great job of explaining kind of the change in that law and how often you and I are seeing situations where we have an improper classification, even though the individual has asked to be classified in that way.
Great. I think we're going to go to the next slide, and I'm going to pass the baton to Tani to talk about updates under federal law that affect us.
Perfect, Scott. And I invite you to interrupt me and take us completely off track as I did you for those last few slides. I also invite people in the chat. Please use the chat if you have questions about any of the things that we're going to discuss, which will be varied kind of over the course of the next 20 minutes. But you see my note is federal update. We're still talking about COVID. So let's jump right into that COVID discussion. The big thing that's been in the news that everyone's been talking about is that idea of vaccine mandates. We had the OSHA 100+ ETS, or emergency temporary standard. I hate having this bullet under the vaccine mandate bullet, because honestly, the OSHA ETS wasn't a vaccine mandate. It included a vaccine component, but it also included a testing component. Either way, though, I'm not going to spend a ton of time talking about it, because we do know that last week the United States Supreme Court stayed OSHA's ability to enforce this rule. The question now becomes, will OSHA withdraw the ETS, or will OSHA and the government attempt to fight in the Sixth Circuit to explain why they in fact did have authority and power? So one of the misconceptions is that the Supreme Court killed the ETS. What it did was it stayed it, but we're still now back in the Sixth Circuit arguing about it kind of from a larger standpoint. The standard to issue a stay is so high that it's unlikely the Sixth Circuit could find that OSHA had the authority to issue this ETS. So really the big thing that everyone's talking about is it's probably in OSHA's best interest to withdraw it, but they don't have an obligation to do so. So that's an update on the OSHA ETS, but a lot of people have been saying to me, but Tani, like, is there anything or any aspect about that ETS that we should be taking into account as we move forward? And it's a really good question, because this was the first time, I mean, we're almost 2 years, we're 22 months into the pandemic. And the question then becomes, is OSHA during this whole time hadn't been giving clear direction. We'd been listening to the CDC, but the CDC, it wasn't an authority over each of the workplace locations. We had rules that were issued in the summer for healthcare providers, but this was OSHA's first attempt to really cover all employers. Recall that every employer is still covered by the general duty clause of OSHA, which it has a general duty to provide a safe and healthy work environment to employers. We now have this ETS, we have this guidance from OSHA that we can use as a baseline or a foundation to understand what their viewpoint is as to things that would create a safe and healthy work environment. So things that I would recommend employers do moving forward: have a COVID policy of some format, okay? Keep employees who have COVID out of the work environment. Some people are probably looking at me like I'm absolutely crazy that we're 2 years in and I'm still saying, like, if you have COVID, make sure those employees aren't in the work environment. But having a policy that specifically states that is important, because we have had situations where an employee has COVID and comes to work because, you know, they don't think it's real, or they think herd immunity is better, so let me share it with other people. Have a policy that says employees with COVID can't come into work. For your unvaccinated employees, having some type of masking policy makes sense. And honestly, at this point in time, based off of what we know about the current strand, having a masking policy just in general may be a good idea, whether or not people are vaccinated or unvaccinated, with the understanding that the CDC guidance is now saying that if you are vaccinated, you know, more than 5 months ago with Moderna or Pfizer, or more than 2 months ago with J&J, that you pretty much have the same implications as someone who's unvaccinated if you haven't been boosted. So following CDC guidance, but also incorporating some of the aspects of the OSHA 100+ ETS, I think would be best practices in guarding against a claim under the general duties clause. So that's for employers. You know, the ETS applied to employers with 100 or more employees, but I think there is elements for all employers that best practices would guard against a claim of violation of the general duties clause. We have the CMS mandate, and last week, the United States Supreme Court upheld the rules that had been set in place under the CMS mandate. So healthcare providers who are receiving Medicare funding would have a vaccine mandate within their work environment. So that's been maintained. The federal contractor mandate, you'll recall that that was executive order 14042 that was issued by Biden in November. And that applies to organizations that contract in one format or another with the federal government, and any downstream contractors as well. Each different agency of the United States government has a different clause and has the authority to choose whether or not this vaccine mandate language will be included in the contracts. Right now, that rule or the executive order has been stayed. It was stayed pursuant to a Southern District of Georgia opinion that was issued on December 7th. An appeal was taken from that decision, so we're waiting for an appellate ruling as to whether or not that executive order will be maintained. Additionally, however, a stay was also issued for Kentucky, Ohio, Tennessee, Missouri, Nebraska, Alaska, Arkansas, Iowa, Montana, New Hampshire, North Dakota, South Dakota, Wyoming, Florida, Louisiana, Indiana, Mississippi, Texas, and Arizona. So in New England, really, we're only talking about New Hampshire, where an additional stay has been issued. Well, why is that important, Tani, when we know that there's a nationwide stay in Georgia? And the reason it's important is because if the Court of Appeals overrules that stay and lifts that stay, there would still be a stay in all the states in which I listed. So in New Hampshire, the federal contractor mandate wouldn't be applicable, but in Massachusetts and Maine and other New England states, it would be. CDC guidance for employers. It is really important that all employers keep up to date on what the CDC is recommending as best practices as it relates to masking, as it relates to distancing, as it relates to isolation, kind of generally. Also, it's important that employers are up to date on wage and hour questions as they relate to COVID-19. One of the questions that Scott and I are getting a lot of lately is as it relates to the COVID-19 temporary emergency paid sick leave program in Massachusetts. There is still money in that pot. So right now, that money is available through April 1st of 2022. The 75 million hasn't been exhausted yet. As soon as it is exhausted, we'll get an alert out to individuals. But what that means is that employees who are out of work as a result of need to self-isolate because they've got COVID, need to recover from a COVID immunization, care for a family member who has to self-isolate, subject to a quarantine order, needs to care for a family member who's subject to a quarantine order. If they can't telework, they're out of work, you have to pay for up to 40 hours of time away from work, up to $850, and you're going to get reimbursement. And I would recommend going to the Commonwealth site for the temporary emergency paid sick leave program, which explains the steps you're going to go through in order to get that reimbursement amount. But the big thing is remembering that they're entitled to that leave and that you're providing that paid leave to them at least in the 1 week. Now, over and above that, those 40 hours, recall that we could have, if they have COVID, we could have paid family medical leave that is available. We have the paid sick leave that potentially is available. We have, if they have COVID, potential ADA questions that we're going to have to cite to. But if the individual is just always in a state in which they've been in close contact and are being told to isolate, we're going to have more limited times in which we need to pay and requirements as to how we move forward. And so Scott and I are getting a lot of questions related to those type of issues as to individuals who just aren't being safe and are constantly being asked to isolate but can't work remotely. Keep those in mind. Also, if you're an employer who has instituted some type of vaccine mandate, keep in mind employees who are given an exemption or an accommodation and are being asked to test. If you have any testing obligations or any other duties that the individual must comply with, that it doesn't, the costs associated with the test kind of aren't borne by that employee, and that we're paying for time associated with the test if they're doing it outside of work hours. So some aspects that you need to keep at top of mind as it relates to COVID. Let's jump to the next slide about the workers and employee mobility. So this is a nationwide study Bloomberg did, and you'll see the data that shows employees and the percentage of US paid days in which individuals are working from home. So previously we had only had a couple percentage of people who were working from home, and now we're looking at about 40% of time is spent in a work from home environment. When individuals are working from home, there are generally a lot of things that we need to keep at top of mind so that you don't end up in litigation, or when the relationship is being severed, your organization is kept in the safest possible place. So let's jump and talk about what some of those things to keep at top of mind are. So first, from a hiring perspective, we have this great resignation, and we're hopefully trying to bring on new employees. Understanding your rights and obligations as it relates to I-9, viewing I-9s for your remote employees, having an individual who is your representative who can physically view the documents. Me simply holding up my social security card or my birth certificate is insufficient. Okay, that doesn't meet the standards set forth for I-9 policy documentations. Making sure that you have a remote work policy is extremely important. Cover safety implications, security implications, confidentiality of documents, the work environment that they're going to be in. As the country has opened up, you know, are they working in Starbucks dealing with secure information on an unsecure network? Those type of questions. Keeping track of electronic monitoring statutes based off of the location where the employee is working from. And understanding where an employee is working from is extremely important. I am probably getting once a week to once every couple of weeks questions concerning how do I deal with employees who are working remotely, who I thought were here in Massachusetts or who were in Connecticut, but come to find out are in Arizona or they're in Colorado skiing for the winter. Does that have implications on my business? And it absolutely does. There's a chance that you may have to be registering to do business in that location. Do you have workers' comp, unemployment in those states and locations? And from a tax perspective, there's a lot of questions as to whether or not you even can require that taxes be paid in that location versus in Massachusetts or another location in which you're operating. So having rules regarding where an employee must work from within your remote work policy is important. Also, there's significant wage and hour implications for non-exempt employees, our hourly employees who are working remotely. We're seeing more and more emails and communications at 10 or 11 at night for an employee who has more of a traditional 9-to-5 job and an indication that they just wanted to have a clean inbox when they came in the morning or something along those lines. Making sure that we're clear about the tracking of time and making sure employees are being paid for that is going to be really important. Scott and I, foresee that in the next couple of years, we will see an increase in wage and hour suits concerning unpaid time that people should have been being paid for, but weren't in this work from home environment because it's just so easy to continue working even outside the time that you're logging. Understanding the location in which the individual is working in is going to be important as well for tax reimbursement provisions. So if you have employees who have moved to California in the middle of the pandemic, and why do you need to know I'm working remotely anyways? Understanding the different state laws that are at issue as it relates to reimbursement for expenses is going to be really important and something to keep at top of mind. And yet another reason why you might want to limit the states in which people are living in who work for the organization. I told you if we had any available time, we'd do a little bit of discussion about the National Labor Relations Board in 2022. I mean, we're doing the year-end review, and the thing with the National Labor Relations Board is that it's always evolving and changing. So me talking about the stuff that happened in 2021 is slightly helpful, but it's more important to understand kind of where we're going. The National Labor Relations Board recently, kind of earlier this week, indicated that very different from the last couple of years, they're going to start to request comment on significant questions that have gone back and forth between employer-focused rights and employee-focused rights over the course of the last 5 years. And under the Trump administration, we saw a very employer-friendly board. The pendulum swings now, and we would expect to see more employee-friendly type discussion and hearing. So the big kind of 5 areas to keep at top of mind are going to be employment status. This goes to what Scott and I were talking about earlier, independent contractor versus employee at the national level. The legality of workplace rules. There was a big case in 2017 concerning Boeing and the ability to have policies that limit recordings in the work environment and whether or not that violates employees' Section 7 ability to discuss the terms and conditions of employment. I know that there's likely a lot of you who have tuned me out right now saying I don't have a unionized workforce, but I'd remind you that Section 7 concerning the discussion of terms and conditions of the work environment applies to all employers, regardless of whether or not they have a unionized workforce. So this legality of workplace rules is one that's really going to focus in on rules and procedures that employers can have in place in order to not violate employees' Section 7 rights. We're also going to see cases concerning smaller bargaining units, consequential damages, and a big one is confidentiality clauses in arbitration agreements and how that potentially could adversely impact Section 7 rights and just general rights as it relates to the Federal Arbitration Act versus the National Labor Relations Act. So that is just a very quick rundown of the National Labor Relations Board, and we finished with 1 minute to spare. If there are questions, Scott and I are available, but otherwise, thank you for joining us today.
Thanks very much. Hope this has been helpful to you in catching up and understanding new developments in Massachusetts law in 2021. Thanks.